So this panel brings together some of the most distinguished voices in international arbitration, counsels, institution, in-house counsel, practitioner to examine these three forces, how to reshape practice, what risks they create, and what must be done. I would like to begin with the common question. So the question answer should not be more than 2 to 3 minutes because we have to manage the time as well. So the common question is that the digital arbitration and the ODR have moved from the pandemic necessity to everyday normalcy. But have they actually improved access to justice or simply made arbitration more complex for the users? Right. So Sidharth, what is your say? They have. So this is what the accessibility. It is available, but you have to.
Absolutely. Thank you, Iram. Esteemed members on the panel, ladies and gentlemen, namaste and a very good afternoon to all of you. Digital arbitration and ODR have evidently moved from a mere pandemic response to an established part of modern dispute resolution. And as you rightly said, the real question, however, is whether they have increased accessibility or made it more convenient for existing users or maybe complex for existing users. So on the positive side, they have reduced or eliminated costs, shortened timelines, increased scheduling flexibility, enabled participation across borders. For many businesses, especially in cross-border disputes, this has made arbitration faster and a more commercially viable option of dispute resolution. It has also created opportunities for maybe smaller or low-value disputes, which would otherwise not have been a more plausible option given the traditional arbitration costs. But convenience should not be confused with access to justice. Because on the flip side, arbitration remains expensive, it is complex and lawyer-driven. And if filing costs, legal costs, and the procedural barriers that we have remain high, technology alone cannot solve exclusion. And there are other reasons as well. There is a great digital divide. There are privacy and data security concerns. There is a lack of standardized protocols for ADR, ODR. And when you say complex, traditional lawyers and institutions, because of the unfamiliarity with these systems, may be averse to adopting to these mechanisms. So the answer is both. Yes, it has definitely improved access, but it has not automatically democratized arbitration. To ensure that there is accessibility and access to justice for everyone, we must have systems which are secure, safe, low cost, user-friendly, multilingual, so that technology breaks open all these barriers and makes it accessible.
Thank you so much, Sidharth. So now, Sidharth, my next question to you, because you are practicing as a lawyer in major arbitration cases and the high-stake arbitration cases, so would like to know that what is the biggest risk when the proceeding go fully digital?
Yes, Iram. So if proceedings... With the permission of the chair. So if proceedings were to go fully digital, I think three big aspects that I would want to speak about: data security, procedural fairness, and enforceability. So speaking of data security, privacy and confidentiality are often regarded as the cornerstone of arbitration. And parties opt for arbitration because they do not want their disputes, documents, or commercial strategies to be exposed to public view. Traditionally, confidentiality was easier to preserve because hearings were physical, filings were exchanged privately, and access remained controlled to a large extent. But today, arbitration, as we know, is increasingly dependent on email communications, cloud storage, AI transcription tools, and other online platforms. And while these tools have improved speed and efficiency, there are digital security concerns as well. And this has also led to arbitration being subject to hacking, unauthorized access, and whatnot. A few examples I can give. In 2015, the Permanent Court of Arbitration's malware attack, where the website was hacked in the middle of a maritime dispute between China and Philippines. In 2025, the National Company Law Tribunal, Kolkata, saw something similar where during a hearing, a perpetrator tried to put inappropriate content. We saw something similar just 2 or 3 days back on 2 occasions before the Honorable Delhi High Court. So even most established institutions, I would say, are not immune. But the way I look at it, I'm an optimistic person. These are not deterrents, rather these are catalysts for creating a stronger and safer digital infrastructure. Parties and tribunals must endeavor to adopt digital safeguards such as end-to-end encryption, multi-factor authentication, and secure data management systems. So that's so far as data security is concerned. Speaking of procedural fairness and due process, they are again a cornerstone and central to arbitration, requiring every party equal opportunity to present its case or to defend the case. However, as arbitration becomes more dependent on technology, the unequal access to technology creates a disadvantage for people who do not have that luxury. Not all parties have equal access to internet facilities, to private hearing places, to devices, suitable devices, etc. We've seen situations, of course, we talk about all the metropolitan cities. I come from a small town, but we've seen places where individuals, organizations do not have that kind of technological advancement. So they are put at a disadvantage. Even when we talk of bigger cities, the shift to virtual hearings can or may impact evaluation of witness credibility or efficiency or effectiveness of oral advocacy. And we've seen all of that. But again, these are not deterrents because remote hearings, virtual hearings have improved access. They have ensured that there is greater participation. On the aspect of enforceability, I would say enforceability is where digital ambition means jurisdictional reality. An award has value only if it can be recognized and enforced. So speed should not be at the cost of enforcement or enforceability. And there are issues surrounding seat of online arbitrations. Seat, as Mr. Banerjee mentioned during the opening address, is a very important aspect of international arbitrations and of course domestic arbitrations also. It's a critical aspect. But in an entirely online dispute resolution scenario, determination of seat and what the seat is unclear. It may be disputed or it may be determined by the platform, the rules of the online platform, which may not align with the domestic laws. And when parties, arbitrators, the online platforms are all in different jurisdictions, what is the lex arbitrae, what is the curial law, where is the seat? These are all questions which will arise. One last aspect here, we've seen many jurisdictions insisting on written and signed awards. A digitally signed award, which may be valid in one jurisdiction, may face challenges in some other jurisdiction. And therefore, UNCITRAL is looking at a protocol, though it's not finalized as yet, as to what is to be done with digitally signed awards. But until then, I would say that parties must try and ensure that in their dispute resolution mechanisms, they visualize this scenario as well, and they specifically provide for validity of e-signed or digitally signed awards.
Thank you so much. The paper is going to be final in June in New York, I think, on the enforcement of awards. So that my next question to you is, because now we see the geopolitical turbulence. So in this scenario, what you see that the arbitration clause today need to be more far sophisticated, anticipating these turbulences or so. So how you will be looking to this aspect?
Yes, of course, Iram.
2 minutes.
Of course. The arbitration clause, which was fit for purpose earlier, may become a liability in 2026.
Yes.
Clauses which were drafted on the assumption of global stability today face geopolitical disruption. Standard boilerplate clauses are no longer enough. Drafters need to keep in mind that sanctions, trade disruptions, tariffs, and supply disruptions, they are all imminent foreseeable risks and not remote realities. Contracts today require carefully drafted force majeure clauses, material adverse change clauses, price readjustment clauses, etc. Taking a cue from what Mr. Ling just mentioned, being a neutral seat is no longer the only criteria. Traditional neutral seats such as London, New York, Geneva, Paris are gradually declining.
Yes.
Because of what we are seeing around us. And also because there is now commerce more regionally distributed. So parties prefer to have venues and seats closer to their regions. And in that vein, new centers such as Singapore, Hong Kong, Dubai, Abu Dhabi, they are gaining traction. The criteria which is today relevant is nationalist sentiment, shifting alliances, and international sanctions, which are increasingly becoming relevant when you're choosing a seat. And therefore, when you're drafting a clause, you need to have that foresight and you need to have that criteria. One more aspect is a rise in sanction-related arbitrations. So those are on a rise. However, some jurisdictions have today introduced provisions which have restricted enforcement of claims coming from sanctioned countries. So this is creating a new problem for the arbitration ecosystem. The key takeaway to conclude, Iram, is that the era of stability is over. When you're drafting an arbitration clause, you please anticipate disruption, allocate geopolitical risk, and preserve, or at least try and preserve, enforceability from the very outset.
The final round is the rapid fire round, so it is just one word you have to say. I'll be asking from the audience also and from the speakers as well. So from the audience now, this question is whether the ODR is revolution or a hype? Revolution. Okay. So one safe seat today, Chair.
Safe seat today.
One. One safe seat today. Singapore. Okay. And the geopolitical disruption, Sidharth, is temporary or a new normal now?
I don't look at it that way. I'll say give peace a chance and peace will survive. And reminds me of Jimi Hendrix when he says, when the power of love overcomes the love of power, the world will know peace.
Okay.